All right. The court is calling 2019 CR 4221 and 2022 CR 3449W, State of Texas versus April Zuniga. Are you the same April Zuniga who was placed on community supervision in 2019 CR 4221 for the offense of driving while intoxicated third or more on November 4th, 2019 for a term of 5 years? Is that you? Ms. Zuniga, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison, $1,000 fine? Did you understand? I cannot hear you.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there an agreement?
We're asking that you deny the motion.
The hearing begins with the judge calling 2 cases against April Zuniga, one for DWI, third or more offense, and another for burglary of a habitation. Right from the start, the judge warns her that by pleading true to violating probation, she could face up to 6 years in prison and a $1,000 fine. April answers quietly, almost hesitantly, "Yes, ma'am." Viewers, what do you think? Is April taking responsibility, or does she sound like she doesn't fully grasp the weight of her words?
Continue her on probation and run it concurrent with the plea agreement.
Ms. Zuniga, are you asking that the court follow that agreement?
Ms. Zuniga, yes, we are asking.
All right, can you?
Yes, please. Yes. Yes.
Are you waiving your right to appeal?
Yes.
Ms. Zuniga, I'm showing you what's entitled Application for Community Supervision. Review that document with your attorney. Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor, I did.
Ms. Zuniga,
Yes, ma'am.
are you not able to find a place other than a commercial restroom?
Okay, no, I just came out of there. Sorry. Because I was in like right here at my son's school for the
The court proceeds through paperwork, making sure April understands what she signed. But then, something strange happens. The judge hears background noise and realizes April might be in a restroom during her court hearing. The judge sharply reminds her, "We don't want to hear toilets." April tries to explain she just left the restroom and was picking up her son. This raises a serious question. If you were in April's shoes, would you ever risk appearing this distracted in front of a judge who controls your freedom?
pickup.
Okay.
Sorry.
So no, is there some other place other than a restroom? We don't want to hear toilets
Oh,
flushing.
no. I mean, no, yeah, I already came out of there. It's just because I was in my son's school, like picking them up. So I'm like, I'm not in the restroom.
So did you just leave the restroom?
Yes, ma'am.
All right. Okay, Ms. Zuniga,
Yes.
I don't understand if you're super distracted at what's going on. So, do you understand what's going on?
Yes, ma'am.
Are you distracted?
No.
Did you understand you're charged with burglary of a habitation by force? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, ma'am.
Outside.
The judge presses further, asking if April is distracted, if she understands her burglary charge, and if she knows the punishment could reach 20 years in prison. April repeatedly says, "Yes, ma'am." Finally, she pleads no contest to the burglary charge. But the judge isn't convinced she's fully present, remarking again that it looks like April is still in the restroom. This moment shows tension between April's casual demeanor and the life-changing consequences at stake.
Like the pre-bargain agreement, the state is recommending that your community supervision be for a term of 4 years. There'll be 120 hours of community service restitution. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing, see, Ms. Zuniga, you are not out of the restroom. You are still in the restroom.
I know,
We're
I
gonna
can't, I
finish
know,
this now.
I had to come back inside.
Yeah. All right, after reviewing states exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. So we're going to sentence you to 4 years in prison, suspended and probated for 4 years, $1,000 fine probated. This is right concurrent with 2019 CR 4221. 120 hours of community service restitution. 40 of those hours will be waived if she provides proof of the COVID vaccination. And Ms. Zuniga, if I could make it so that you're not involved with anyone until your children are of age and can take care of themselves, I would. But
After reviewing the evidence, the judge accepts April's plea and sentences her to 4 years probation with community service. Interestingly, the court offers to waive 40 hours of service if she shows proof of a COVID vaccination. But then comes a powerful warning. The judge says if they could legally stop her from being around certain people until her children were grown, they would. Instead, April is told she must choose carefully who she allows into her life and around her kids. Do you think April will listen this time, or is she headed down the same path again?
in each of these cause numbers, I'm showing you what's entitled motion to revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
All right, I'm gonna need you to speak up.
Yes, ma'am.
Are you the same April Zuniga who was placed on community supervision in 2019 CR 4221 for the offense of driving while intoxicated third or more on November 4th, 2019 for a term of 5 years? Is that you?
Yes, ma'am.
And are you the same April Zuniga who was placed on community supervision in cause number 2022 CR 3449W for the offense of burglary of a habitation on April 11, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
State.
Violated condition number 3 on or about the 9th day of October 2022 until the 15th day of October 2022 in Bexar County, Texas. The defendant, April Zuniga, then and there associate with.
The court calls her case again, this time for probation violations. April admits to associating with people of harmful character who were negotiating drug transactions. She pleads true. The judge questions why April should avoid prison, when all she's done is pick up new charges and surround herself with the wrong people.
State ISS. And that's in the summary, court summary from Mark Hewitt.
Okay, so Ms. Zuniga, why should I just send you to prison? It appears that you haven't done anything except pick up a new case and hang around people you're not supposed to be around. So why should I just send you to prison?
Because I mean, I was doing everything like as of my classes, my UAs. I was
No, you were in an establishment that's primary purpose was to sell alcohol, and they said you were arranging some kind of drug sale with somebody.
I guess no, they were like I guess they were using substance abuse.
I can't understand a word you're saying.
I mean, I wasn't in the middle of any drug use or anything like that.
The main thing I noticed is that Judge Glenn, whom I know and I respect, said that, and he knows this much better than I do, that he would be willing to keep her in drug court if she went to state ISF. Now,
I mean, I know him, I respect him too, but I still don't understand why I should do it.
Well, again, I don't know the details of what happened with these individuals that she was associating with. She's not charged with any criminal offense other than me. So she's not accused of being involved in a drug deal.
April struggles to explain, insisting she wasn't directly involved in drugs, but her words are unclear, almost incoherent. The defense argues that drug court still sees potential in her, noting Judge Glenn is willing to accept her back if she completes treatment. Even so, the courtroom tension rises. Why should the system keep giving her chances when she keeps slipping? What do you think? Should repeat violators be given more chances if rehab programs believe they can change?
People that they don't think could benefit from drug court and could succeed. Judge Glenn feels that she needs to go to inpatient and ISF is appropriate. I'm only asking the judge to give her that opportunity based on what the recommendation from Judge Glenn is.
See, I don't know why they didn't just keep her then and send her to ISF.
Well, I don't know how that works because, I mean, they accused her of violating her probation. So I'm assuming that, do they have their own MTR deal in drug court?
I mean, they could just not send her in.
It-
We're gonna go off the record for,
Yes, Judge.
and we're not on the record. Ms. Zuniga, how old are you?
32.
All right, so here's the thing. Could everyone please whisper? You've already entered your pleas are true. And I understand that people are in different seasons of their life. And I understand that sometimes people are treated badly in life. I understand that sometimes people are misused and abused in their life. But I went into the hallway because I wanted to speak with Judge Glenn, and your attorney was present and the state's attorney was present. It's very difficult to speak on the bench with another judge. So that's why we were in the hallway. And we were discussing things with Judge Glenn, and here's
The judge takes a moment to step away, consult another judge, and comes back with perspective. He reminds April, and everyone in the room, that changing people, places, and things is critical for recovery. He admits even he, Judge Boyd, would struggle if told to suddenly surround himself with drug dealers. His message is clear. If April wants a future, she must break away from the circles dragging her down.
But then when I started thinking about it, for example, if people told me to change people, places, and things, and they say, okay, Judge Boyd, this is what we want you to do. We want you to hang out with people who sell drugs. We want you to hang out with people who use drugs. That would be very difficult for me because of the circles I'm in. I don't know a lot of people who use drugs or sell drugs. Now I have people who come before me in court who do that, but it's not like these are the people that I am having dinner with or lunch with or say, hey, let's go do painting with a twist. And while we're there, maybe we can sell drugs. So it would be very difficult for me to change people, places, and things. And so in your situation, these are the people you've been hanging with. But if you want your life to be successful, and if you don't want to end up in prison, then you're going to have to change your people, places, or things. I was about to send you to prison, and not for 2 years. I was going to send you to prison for 6 years on one case and 4 on the other. And you need to make a decision on whether or not you want to go to prison. And you have children?
Yes.
You need to start asking yourself each time you're getting ready to do something, you need to ask yourself, is this something that will result in me not seeing my children for 6 years, or not seeing my children for 4 years, or going to prison for 6 years, or going to prison for 4 years? Do you understand?
Yes, ma'am.
At some point, you need to start.
The judge delivers a wake-up call. I was about to send you to prison for 6 years. He tells April she must start putting her children above her own wants. Every decision, he says, should be measured against one question. Will this choice take me away from my children for years? The weight of that statement hangs heavy in the courtroom.
If you don't want to do safety with them, you need to tell me now, because if you don't want to do safety with them, then I can send you to prison. We can move on to the next person. Do you understand?
Yes, ma'am.
So if they order you to safety, are you going to be doing that?
If that's the only choice I have for the.
Yeah, that may be your only choice.
And they won't have state ISF.
What I'm telling you is, my question for you is, if they order you to go to safety, are you going to do it?
Yes, ma'am.
That's my only question. We can't write our own programs. If you could write your own program, guess what? You wouldn't be on probation for this because you would have been successful at it. So I'm not making a ruling. We're going to refer her back to felony drug court, and she's to remain in custody for felony drug court.
In the end, the judge doesn't send April to prison. Instead, he refers her back to felony drug court, keeping her in custody until they decide her next step. His final warning is chilling. If you don't change, one of two things will happen. You'll either end up in prison or overdose. Either way, you won't see your children again. This case of State of Texas versus April Zuniga shows the razor-thin line between a second chance and a prison sentence. April received probation instead of hard time, again, but the judge made it clear, unless she changes her life, her children will grow up without her. What's your opinion? Should April have been sent to prison immediately, or does drug court give her the best shot at redemption? If you found this courtroom moment as gripping as we did, don't forget to like, share, and subscribe for more real cases where justice, redemption, and second chances collide inside the courtroom.